So yeah, I've been working with Jonathan from Birketts for a few years now. I think about 6-7 years maybe, something like that.
Show my age.
Yeah, and he's been helping us do these employment law seminars, and yeah, they're really good. And I don't know whether a few of you know have attended before, so yeah, you know how useful they are. We are a commercial recruiter. We support local businesses, and this event we've been able to put on free of charge because you guys support us. Many of our clients are here today, and we hope you'll continue supporting us in the future. And we're not just here for recruitment. If you need market advice on CVs, salaries, anything like that, we're here to help. So hopefully today will be of use, and I'll hand over to the very capable Helen and Jonathan.
Good morning, everyone. Thank you for coming. I am Helen Gaylor. I'm an employment solicitor at Birketts, and this is obviously my colleague John, who's a senior associate at the firm. We're based in the Chelmsford team at Birketts, so we have 5 offices. We are a full-service legal firm. We have offices in Ipswich, Cambridge, Norwich, Chelmsford, and now London. I think we recently acquired that in 2020, so now we've got a city presence, which is great. We have we have 90 partners now, 11,000 active clients, so 5 offices, 100 private clients, 200 property lawyers, and now I think it's about 900 staff now, so we're really growing and increasing the foothold that we have over the greater Anglia region. Next slide, please. So we also have an app. You can access this via your slides, hopefully, and for those of you that haven't got copies of the slides, I do apologise, they will be circulated to everyone afterwards. So you can scan this on your phone or on your Android. The employment app is basically a resource for lots of employment updates and guidance notes, basically, that you can have access to. Have a go. If you've got any queries about it, do email us afterwards and I'll be happy to get in touch. But from what we've heard, it's very useful for HR professionals, so something that I'd recommend. We also offer various in-house training courses, which is a shameless ploy. So just to let you know that if you ever have any training needs from an HR or employment perspective, we can assist you with those, anything from GDPR to general employment updates. So we have a new cohort for our HR professionals course starting in January 2023. It's an annual course. It's made up of 12 modules every month. These are either virtual or in person, and the in-person ones are usually in our Ipswich office. We've had some excellent feedback from them, and those are just an idea of the courses that we cover on them. And for our September cohort, I'm actually delivering some of the training for equality, diversity and inclusion. So that's on the 7th of December. So I'll be doing that with my colleague Johnny, who is based in the Cambridge office. But we've heard excellent feedback, so if you'd like any further details of that, and if there's anyone that within your team who you think could benefit from just a bit more employment law training, it's good to just keep up to date with it, and do let us know. What have we got? So just a run through of the agenda for today. So Jonathan is going to be covering working time and holiday pay. I will be covering employment law case updates. So that includes cases on employment status, unfair dismissal, and also beliefs in the workplace, which is really quite current at the moment, and I'm sure a lot of you have heard a lot about this in the news, especially with the Maya Forstater case and her gender critical beliefs. It's very poignant at the moment. John will then be covering sickness absence, and we'll be touching upon the impact of long COVID in the workplace, which we hope you'll find helpful. And then at the end, we'll have an opportunity for you guys to ask some questions, and we'll answer as much as we can. And I think that's about it. So what have we got next? Okay.
I thought there might be one day, I mean, it's been a few years since we've done these, and I thought that we might actually get away without doing a seminar that includes something to do with working time or holiday pay. We've not reached that time yet, so I'm afraid you're stuck with holiday pay and working time again. I think what I wanted to do first off was just start with a slight slide on a summary, really giving you the background of where we get to with working time, because there has been some changes in the last few years, going back to Brexit and the subsequent Withdrawal Act. So initially, Working Time Directive is where all of this tends to emanate from. That was then into UK law via the Working Time Regulations, 98, which is what we've still got in place. That was then preserved by the Withdrawal Act, which was the stuff that said, right, well, we're drawing a line in the sand and things can stay and other things go. It becomes part of what's called retained EU law. So that's sort of where we get to. Not a lot has changed statutory-wise since then. So effectively it's maintained the status quo. What does that mean? So in terms of the key concepts, Regulation 13, 13A and 16 set out the main rules that we need to really be aware of. Now that's the full entitlement of 5.6 weeks paid holiday per year. So that's for a worker who is at work for 5 days a week, and they'll be therefore get 28 days. So that's what the 5.6 equates to, and that's statutory leave per year. Obviously companies, and quite often do, grant more than that. In that case you have statutory and then some contractual leave on top. Now 4 weeks of that is guaranteed under EU law, going back to the working time directive I was talking about. Now in addition to that, the UK provides the additional 1.6, so that makes you up to your 5.6, and that's under Regulation 13A, as I said. Now the calculation of how much a holiday pay you should get is dealt with something completely separate, and it's dealt with in the Employment Rights Act. And effectively what it says, the amount of pay a worker should receive in respect of that holiday is based on a week's pay, which is calculated in accordance with sections 221 to 224 of the Employment Rights Act, which is I've said there. So let's put some context to all of those things. First off, we have an update on Smith v Pimlico Plumbers. Now this is a case that's been bouncing around the courts and tribunals up and down for a long time. Now primarily this is a case that was involving employment status. So it's not ordinarily, you would think, a case about holiday pay or working time. Now that's part really due to really what we're dealing with there was self-employed workers, self-employed individuals, and whether or not they were workers. The Court of Appeal has given its decision on that to say that yes, they were workers. The other aspect of that case, and this is relevant today, is the issue of accrued holiday, because if he's a worker, Mr. Smith, then presumably he would or should have had some holiday pay. So the brief facts of this case, now in 2018 the Supreme Court found that Mr. Smith was a worker rather than a self-employed contractor, as I mentioned. The implication of that was that he would be entitled to take paid holiday under the working time regulations. As he'd been classified as a self-employed individual, Mr. Smith, however, had not taken any paid holiday. So he might well have had time off, probably did, in the time he's been there, but he didn't actually get paid for it. So Mr. Smith's claim then went back to the Employment Tribunal to determine, well, how much holiday pay should he get, if any? And what did they say? Well, you're out of time. Okay, so they said, well, you haven't brought your claim within 3 months of the last holiday pay period, so I'm sorry, you don't get any holiday pay. Also found that he could not carry forward any holiday entitlement to holiday pay where he had taken periods of unpaid holiday. So he wasn't very happy about that, as you might imagine. So he decided to appeal that to the Employment Appeal Tribunal, and the original decision was upheld. Still wasn't happy with that, so it went to the Court of Appeal, and this is where we come in now. So the Court of Appeal found that Mr. Smith could claim in full in respect of his unpaid holiday entitlement. Now that entitlement goes back to the start of his employment contract. Okay. Now the reason for that is the court stated that the right to take annual leave under the Working Time Directive was a single right to paid leave rather than separate, distinct rights and to be paid for it. So the failure by an employer to pay leave at the time it's taken meant that there had been a failure to ensure that he had benefited from annual leave. Okay, so I suppose they looked at it more in the round, holistic, I suppose, rather than the minutiae of it. Now, Mr. Smith had not been permitted to take any paid leave, as I've said, so therefore he was entitled to receive his 4 weeks, not the 5.6, but the 4 weeks, because that's under the EU law, as provided under the directive on the termination of his contract. Now, a claim in respect of this entitlement must be brought within 3 months of when his engagement, should we say, he wasn't employed, ended. So he wasn't out of time. So in other words, that claim doesn't crystallise until such time as he leaves, because the claim was brought under the working time regulations, the ones I've just gone through, rather than as an unlawful deduction from wage. And there's a couple of consequences of that. Clearly, this is going to be, so for all of those in the room who potentially operate in the gig economy, there could be some arguably potential expensive consequences. but only where people have been misclassified as workers rather than as independent contractors rather than workers, and have not had holiday pay. So really what employers should be doing is carefully considering employment status at the outset, and indeed as the employment or the relationship goes on and how it works in practice. Following factors, things to bear in mind really when assessing employment status: the extent to which there may be mutual obligation, so that's to offer work and to accept it; the degree of control that you might have over the individual, can you tell them when and where to turn up, or do they turn up when they want? Nature and the duration of the agreement, by itself not determinative, but for example, if you've been engaged on a self-employed contract for a full 4 years, 5 years, without any breaks, you're not working for anyone else, it perhaps leads to a conclusion that they're not. And things like integration into the business as well. Are they subject to the same disciplinary rules, etc.? And who provides equipment? They're all really just an overview of the relevant sort of factors that you take into account when you're assessing employment status, all of those points that were brought up in Pimlico as well. What it won't be enough is to have a contract in place, a sort of shiny, brilliant contract saying this relationship is one of independent contractor. And that goes back to Uber decisions and all the ones that I'm sure you've heard of before, that effectively says, look, the contract is important, obviously have one, but what is equally as important is how things actually work on the ground. No point just saying you're an independent contractor if in reality there are lots of factors pointing towards being a worker. Employers will also want to note that in these circumstances the 2-year backstop that applies to unlawful deduction from wages claim wouldn't apply. So that was because the claim here was brought under the working time reg, as I said, rather than unlawful deductions. The reason being that the unlawful deductions does have a 2-year backstop. The government introduced that a good few years ago now to try and limit the amount of back pay and things like long-standing holiday pay because of a number of decisions, Stringer, Scotland, mainly to do with sickness and holiday accrued during sickness. So the right to pay holiday in respect of the 4 weeks leave under the working time regs will accumulate from year to year, and it will be payable on termination. Now the court also, just for another point, the court also expressed a view that the 3-month gap that would normally be seen to break the chain of a series of deductions was actually no barrier because Parliament didn't intend that to be the case. So that was their interpretation, which is very different to other interpretations that we've seen before. So that clearly is an aspect that will no doubt feature in future litigation, but it gives a good indication really, we've got quite high authority of the Court of Appeal, that it's likely to make it easier for workers to make claims for periods of underpaid rather than unpaid, which is what Mr. Smith was, holiday entitlement. So I think there's 2 aspects to that case that probably just need to give some thought to. Now the next one, Harper Trust. Fairly well publicised. Certainly we have given a lot of updates in relation to this particular case. I'll run through briefly for those who may not be aware. This goes back, again, this goes up to the Supreme Court. So we were awaiting for quite some time the decision of the Supreme Court, which came in July this year, so relatively recently. And it's a long-awaited appeal against the Court of Appeal's decision in Harper Trust v Brazil. Now the Supreme Court here held that holiday entitlement for a permanent employee, but an employee that only worked half of the year, shouldn't be prorated down to the month's worked. So the facts were, in brief, were these. Miss Brazil was employed as a music teacher. She worked term time only for variable hours each week under a permanent 0-hour contract. There was a contract that existed throughout. There was always a contract there. There were, however, times when she didn't work, and there were times when hours varied. Her holiday pay was initially calculated, taking her average week's pay and paying her a third of her annual holiday entitlement following each term. However, from September 2011, the calculation changed. Now, the Trust calculated the number of hours worked each term, then took the 12.07 of the total and paid the employee for those hours at her hourly rate. Now, the 12.07 was actually ACAS guidance at the time. You may well have used it yourself. It's quite a nice, easy way, because these things can become incredibly complicated to try and work out. So it was a fairly easy way of doing it. Now, when Mrs. Brazel looked at it, she claimed that by adopting that method and by changing the method of calculating her holiday pay, she was being underpaid for her holiday. So, as you might expect, she brought an employment tribunal claim, and that was for an unlawful deduction from wages. Now, her claim was initially dismissed by the employment tribunal, but upheld by both the Employment Appeal Tribunal and Court of Appeal. The Court of Appeal during that litigation coined the term part-year worker to define this type of contract. So it was sort of looking at a new, tested area. So that's where you have an employee that does not work a full year or 4 weeks, so will work on a part-time basis for part of the year. But there is an employment contract that is throughout, including periods when they're not either working or being paid. So where do we get to in the Supreme Court? We then get to, that's the most recent decision, which rejected the trust arguments that holiday pay must be prorated to take account of weeks not worked. So it held that Ms. Brazel was employed on a permanent basis as entitled to receive 5.6 weeks leave per annum. That is exactly as the working time regulations say. The court rejected the method adopted by the school to calculate her holiday pay. It considered that the calculation of holiday pay under the working time regulations specifically references the methods for calculating a week's pay, which it simply said, we need to apply that. What the trust were trying to do was effectively come up with fairly weird and wonderful ways of doing it to justify the way they had done it, but it departed quite significantly from what the statute actually said, which is this is how you do it for an abnormal, for somebody who works no normal hours. So as she had no normal hours of work, a week's pay was required to be calculated in accordance with section 224 of the Employment Rights Act, but with a reference period extended from 12 to 52 weeks. So that changed in April 2020, because the reference period previously was looking back 12 weeks. What you do now is you look back a longer period of time, which is 52 weeks. Now, why is this also relevant? Well, under section 224, any weeks in the reference period in which the employee does not work, are disregarded for the purposes of working out holiday pay. So what the trust effectively said is, well, if you do that, then that effectively artificially increases the holiday pay. And they dismissed that argument, and they said they would most likely, in certain instances, part-year only workers would receive a proportionally higher amount of holiday pay than those working regular or part-time hours. Now, despite that, the court said any favouring was not so absurd to justify a wholesale departure from what the existing statutory scheme said, which effectively would have been what would have been required for the trust's calculation methods. So, where does that take us? What does it actually mean? Decision will be most immediately felt by those organisations engaging permanent staff who only work for part of the year. Now that could be perhaps schools working term time, as we had a music teacher here, who are now entitled to a more favourable holiday pay calculation. Could be relied upon as well by those working irregular hours for parts of the year only, especially where they're still adopting the 12.07% as per the old ACAS guidance. What this decision does not do is change the calculation for holiday pay for those working regular hours throughout the year, whether part-time or full-time. Okay, so it's not a change to part-time. You can still prorate down. What this is dealing with is slightly niche, slightly more niche, less common, whereby you've got people who are engaged on a permanent contract but just working bits of the year and not work and having weeks where there is no work. So, what can you do about it? Well, probably the first thing to do, as you might expect, is to try and work out whether you've got any workers or employees who may fall within this sort of part-year worker trap, as it were. If you have, then what do you do? Well, a couple of options. Now, none of these are tested, but as yet, because it's a fairly new decision, but we've had to think about what really practical advice we can sort of think of. One is to divide pay equally across 12 months, or paying a minimum amount in each week. So what does that do? That means there's no gaps, and the gaps are effectively the problem. So the important factor there is that the employee is paid for each week they are employed in, so you're avoiding any 0 weeks so as to keep the average holiday pay lower. The other is to place casual or variable staff hours on zero or a type of zero worker contracts or something similar. Now, what do I mean by that? The issue with Miss Brazel was that she was employed on a permanent contract and she was employed during periods in which she was not required to provide any teaching. Had she only been engaged to perform specific teaching assignments, so she needs to do an assignment for 2 weeks here and then it ends, that may have been different because there is arguably, or you want to assert, that there is no gap there where there is any obligation. So in other words, she would have got paid her holiday pay at the end of each assignment for that bit of work. Now that's one potential. As I say, that's not tested. We've looked at that, and there is always a risk with those sorts of things that where there is a very artificial arrangement, it is always possible that courts could take the view that there is still like an umbrella contract that sort of governs it all. I think when I've been looking at those things, we've been looking at having a specific assignment for a relatively short period of time, and then making sure that that is ended, holiday pay is paid, and that there is a meaningful gap within before anything else is done. In some circumstances, that's not going to work if we're just for bank staff potentially or something like that. So, but that is a couple of options there. And in actual fact, bring on to the next slide. For those who, because holiday pay is a bit of a minefield, and that's no exception for lawyers as well, the government has published 2 updated sets of guidance, quite long, quite detailed. However, they take account of the Harper Trust decision. They're a good useful resource as it gives a sort of a detailed practical advice on what to do, and also some work examples. Now, it won't give you advice on how to sort of change things, but it will certainly tell you how you should calculate things. So it's a good start, it's a good place. It's not on the slide, but I can circulate the details, or we can circulate the details. 2 of our partners in the Cambridge team did a specific webinar on this particular topic, and that's available on YouTube. Another shameless plug, it might be on the app as well, which by the way is free to download. It may be on there, so you can actually see some more detailed guidance, and that's all completely free.
Okay, that'd be good, thank you.
Okay, I'm now going to take everyone through the employment law case updates. Bear with me, they're quite meaty, but if anyone has any questions, then please do ask, or we can save them to the end, that's completely fine. So the first case that I'll be looking at is one with regards to unfair dismissal, and it's the case of Nursing and Midwifery Council versus Mr Somerville. So Mr Somerville was a barrister, and he was appointed by the NMC to sit on their Fitness to Practice Committee. Now, he was actually engaged under a series of 4 consecutive consultancy agreements, which specified that he was a self-employed contractor. Watch this space. So the council agreed to provide reasonable notice of committee hearings that he could sit on, and he was free to choose whether or not he sat on them. There was no obligation on the council to provide hearings for him to attend, and equally there was no obligation on him to attend any. So in practice, he provided his dates over a 6-month period of when he was available, and he could occasionally refuse hearings, and if he had accepted them and last minute he said that he couldn't attend, there was no penalty. So what he ended up doing was bringing a claim for holiday pay in the employment tribunal, but obviously in order to succeed in that claim he needed to be able to prove that he was either a worker or an employee. So the employment tribunal held that he was not an employee because there was insufficient mutuality of obligation with regards to his engagement. However, it did hold that he was a worker in respect of every hearing that he attended at the NMC. So the NMC didn't like this decision, and they appealed to the Employment Appeal Tribunal, and this was dismissed. But then they appealed again to the Court of Appeal, who then also dismissed their appeal again. So the Court of Appeal held that even without the existence of an overarching contract imposing an obligation to work, it didn't prevent the finding that he was a worker every time he attended a hearing. Mr Somerville agreed to provide his services personally every time he attended a hearing, and the council was neither a client or a customer of a profession or business carried out by him, as he was a barrister. So this was consistent with the terms of worker under the working time regulations. So the Court of Appeal also went on to say that it didn't consider it necessary to provide an additional requirement for an irreducible minimum of obligation for worker status to arise. It had a specific agreement to provide services on a particular occasion, which amounted to a worker's contract, and it was irrelevant whether or not the parties were not obligated to provide or accept work under the overarching contract, or the lack thereof. So the court in this case actually referred to the decision that was made in Uber, which I'm sure you're all very familiar with, in which it was held that Uber drivers were providing services under individual contracts each time they worked. And the Supreme Court was satisfied that if an individual is entirely free to work or not and owes no contractual obligation when not working, it didn't preclude a finding that they were a worker on every occasion that they worked. So I think this just proves to us that there's quite a low bar for individuals to obtain worker status, which is something to bear in mind. And even if there isn't a minimum amount of work that needs to be provided, that can still give a rise to worker status. So do bear that in mind with regards to employment status, which again is a bit of a minefield. Have my next slide. Thank you. So this claim is with regards to whether or not the employer exercising a pylon amounts to unfair dismissal following a resignation. And the answer is no. But the claimant resigned and he gave 9 months' notice to terminate his employment. And the employer then thought, well, we'll bring forward your termination date and we'll pay you in lieu of your remaining notice period. So the claimant then, as a result of that, brought a claim for unfair dismissal in the employment tribunal. So the employment tribunal dismissed this, and then the claimant appealed to the employment appeal tribunal. So the employment tribunal again dismissed the appeal and upheld the employment tribunal's original decision that he had not been dismissed, as he had originally resigned, and all the employer had done is just brought forward his employment termination date. Now the employment appeal tribunal actually relied on a case called Marshall Cambridge Limited versus Hamlin, which is a 1994 case, in which the EAT had concluded that a resignation was not converted into a dismissal when the employer exercised its contractual right to issue a pylon. It was merely altering the date in which the termination took effect. So the EAT in this case expressed some reservations about the legal reasoning provided in the Marshall case. However, it didn't see that any decisions in there were manifestly wrong so that it could diverge from the actual case, so they had to stick with it. The EAT could only depart from previous decisions in the employment tribunal in very limited circumstances, and the fact that the EAT had expressed these reservations about the legal reasoning suggests that if the case was pursued to the employment to the Court of Appeal, that it could be overturned. And we understand that the claimant is actually seeking permission to take this case to the Court of Appeal, so watch this space. So my next case is about sex-related harassment. Now this case was actually published in the media quite a lot in May 2022. So an employment tribunal in this case upheld the claims of unfair and wrongful dismissal and for harassment related to sex as a result of the claimant being called a bold expletive. The case was widely and inaccurately reported in May 2022. So the tribunal was satisfied that there was a connection between the word bold and the protected characteristic of sex, since far more men suffer with hair loss than women. The tribunal held that the term is inherently related to sex, and it also drew parallels with a previous decision where a man was found to have sexually harassed a woman by commenting on the size of her breasts, which is a comment far more likely to be made to women than men. The tribunal in this case was also satisfied that the comment amounted to conduct that was unwanted, and it was a violation of the claimant's dignity, and it created a hostile working environment for him, which obviously is the requirements to bring a harassment claim under the Equality Act. It was done for the purpose relating to the claimant's sex. It therefore met the test for sex-related harassment under the Equality Act, which is unwanted conduct relating to an individual's sex or another person of another sex. Now, please bear in mind that this isn't a case for sexual harassment, as some reports described it, which is unwanted conduct of a sexual nature, so those two are different, but I can see why they would be reported interchangeably. The tribunal's decision notes, and I found this quite funny, that the claimant was not concerned by the using industrial language within the workplace. So I dare say, to an extent, he gave as good as he got. However, the tribunal did say that he expressed himself in Anglo-Saxon terms. Now, we have looked into this, and we could not pin down what that meant, but I think we can use our imagination there. But apparently he was particularly affronted by the comments made about his appearance, which the tribunal deemed had crossed the line. So, one to bear in mind. So I thought I would move on to beliefs in the workplace. Now this is something that as a firm we have discussed quite a lot internally, and you'll see why, and that is mainly because the decisions are quite complex and it really is very fact specific when it comes to how employees or workers express these in the workplace. So I'll start off with the Maya Forstarter case. Now she was engaged as a taxing consultant for CGD, and Maya believes that a person's biological sex is a material reality that shouldn't be conflated with gender or gender identity, and these are what we refer to as gender critical beliefs. So while an individual may choose to identify as a certain sex, their legal sex doesn't change under the Gender Recognition Act, and her belief is that even if someone chooses to identify as another sex, that it doesn't change their actual sex in practice. So following her tweets in relation to her beliefs on Twitter, with regards to this and the proposed amendments to the Gender Recognition Act 2004, some of her colleagues complained to the workplace, and this led to an investigation because it was thought that her comments were transphobic and offensive. So when they raised the issue of her expressing her views in the workplace, she said, "I'll agree to add a statement to my Twitter profile that says all the views are my own and not of the CGD." She also, and these points are important with regards to the decision that was made, she consistently said that she would use someone's preferred pronouns, but appreciated that her right to advocate gender critical beliefs should be kept outside of the workplace and not inside. She said to her manager, "You're right on tone, I should be careful and not unnecessarily antagonistic. Of course, in social situations, I would refer to any trans woman as an honorary female and use whatever pronouns, etc. I wouldn't try to hurt anyone's feelings, but I don't think that people should be compelled to play along with literal delusions." She also accepted that her views should be kept out of the workplace and would only offer up her views if she was invited to speak about them, because she had been known for bringing in pamphlets on her gender critical views and leaving them in the staff room, for example. So after the CGD's investigation, she was not offered an employment contract to work on a particular project. Her consultancy agreement wasn't renewed, and her visiting fellowship was not renewed for a third year. So obviously she brought claims in the employment tribunal for discrimination and victimisation. And at a preliminary hearing in the employment tribunal held that her gender critical views did not qualify as a protected religion or belief under the Equality Act. This is because her belief did not fulfil the necessary criteria for protection, i.e. it wasn't worthy of respect in a democratic society, it was incompatible with human dignity, and it conflicted with the fundamental rights of others. So she appealed to the Employment Appeal Tribunal, and the EAT upheld the claimant's appeal and accepted that her beliefs were protected under the Equality Act. And what it did was it adopted the approach under the European Convention on Human Rights and held that a philosophical belief will only be excluded from protection under the Equality Act if it is the kind of belief that would be considered an affront to the EHRC principles, akin to Nazism, totalitarianism, or espousing violence or hatred in the gravest forms that were not worthy of respect in a demographic society, which is obviously that's a very low bar. So the EAT considered that the claimant's gender critical beliefs were widely shared in society, and while they didn't seek to destroy the views of trans individuals, even though they could be seen as offending them, they were still protected under the Equality Act. And although the beliefs might be offensive to some and may have the result to potentially harass people, they still fell within the Act, the Equality Act. So in the end, she ended up bringing successful claims for direct discrimination in respect of the respondent's decision not to offer her an employment contract or to renew her visiting fellowship. And she also brought a successful claim for victimisation against both respondents in respect of her profile being removed from the CGD website. And her other claims for indirect discrimination were dismissed. So the consequences of this is that it clarifies that even the most extreme beliefs will be worthy of protection under the Equality Act as a protected belief. And that protection under the Equality Act, again, is quite a low bar. And again, that is demonstrated in the Carrick case, which I'm going to come on to shortly. So in the of Dr. McCarrick versus the Department for Work and Pensions and Advanced Personnel Management Group. So Dr. McCarrick was a Christian doctor, and he contracted with the second respondent as a health and disability assessor. So part of his role involved carrying out disability-related assessments for claimants on behalf of the Department for Work and Pensions. So the role also required him to comply with the DWP's pensions on gender reassignment, and that included using people's preferred pronouns. However, at his induction, he informed the head doctor that he couldn't use people's preferred pronouns, as this was inconsistent with the gender that they were born with. So again, gender critical beliefs like my for-starter. And that obviously conflicted with his religious beliefs. So his beliefs, or lack of belief, was that in the truth of Genesis, a person cannot change their sex or gender at will, and attempting to do so is pointless, self-destructive and sinful. A lack of belief in transgenderism and gender fluidity, such that he does not believe, A, that a person can change their sex or gender, 2, that impersonating the opposite sex may benefit for a person's welfare, and 3, that society should accommodate or encourage such impersonation. So he did not believe in these things. He also believed that it would be irresponsible and dishonest for health professionals to accommodate or encourage a person's impersonation of the opposite sex. So initially, the respondents considered how they could accommodate his role in the workplace. They consulted internally, they also consulted ACAS, and they also consulted the Good Medical Council's guidance and considered the sensitivity of the areas in which they worked. They considered 2 possible methods of accommodating him, and that include giving him a non-customer facing role, which obviously wasn't appropriate given the nature of the work that he had to carry out. And they also considered ensuring that he only assessed non-transgender service users, but neither of those were appropriate given the level of work that he had to do and the nature of his role. So on the 13th of June 2018, a meeting was held with Mr. Owen of the second respondent, who was quite high up, to clarify Dr. McCarrick's position as to his belief, and he acknowledged that the claimant's job was at risk. So on the 14th of June, Dr. McCarrick left work at 11 o'clock in the morning and said he couldn't complete the assignments due to the ongoing situation. The day after, on the 15th of June, he claimed that he had been suspended and asked for the suspension to be confirmed in writing, with written reasons. Mr. Owen emailed him stating he understood that the claimant had left work by choice and that he didn't feel that he could return until the situation was resolved. So on the 18th of June, Dr. McCarrick accepted Mr. Owen's notes of the initial meeting on the 13th, but added in his belief deriving from Genesis that a person cannot change their sex or gender at will. So he's reiterating his belief there. On the 25th of June, Mr. Owen made the following request, having consulted with the first respondent. And he said, on behalf of DWP, we would like to ask you one final time whether you would follow the agreed process as discussed in your training, and that in any assessment you conduct, that you refer to the customer by their chosen sexuality and name. We are, of course, happy to provide help and support on this. If, however, you do not wish to do this, we will respect your decision and your right to leave the contract. So Dr. McCarrick responded that due to his faith, he couldn't do what was being asked of him. And he acknowledged, Mr. Owen acknowledged his email and thanked him for his work, and the claimant responded by saying that he had been dismissed. So he brought claims against the respondents for direct discrimination, harassment and indirect discrimination, relying on his protected belief, or what he deemed to be protected. So in the Employment Tribunal, they found that his beliefs were not protected under the Equality Act, and that even in the alternative, the tribunal held that if they were protected, he had not been treated less favourably because of them. So he appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal held that his beliefs actually were protected under the Equality Act. And it deemed that the Employment Tribunal had held too high a threshold in implying the criteria for whether a belief is actually protected under the Equality Act. And that is whether that belief holds respect in a democratic society, isn't incompatible with human dignity, and does not conflict with the fundamental rights of others. So that bar was held to be too high by the Employment Tribunal and was overturned by the EAT. The EAT were therefore satisfied that his beliefs were protected, as Ms. Four-Starter's were. However, it was satisfied that he had not suffered direct discrimination or harassment on the grounds of those beliefs. So the ET had been entitled to draw a distinction between Dr. McCarrick's beliefs and the way he wished to manifest those beliefs. And I think the issue of manifesting beliefs in the workplace is something that the employment tribunals will look at in great detail when looking at these cases. And that isn't to say necessarily that employees cannot express their views within the workplace, and it isn't necessarily to say that employers can't put into place policies on how those views are expressed within the workplace. But I think this comes down to the facts of every situation, and that employers and employees need to be careful. And I think the issues of respect and hurting others' feelings within the workplace is something that is going to be considered. I think we have put together a couple of policies for various clients on this, but it's quite a woolly subject, and it's something that we're discussing at length within the firm. So it's just something to be careful about when this is going on, especially with regards to social media now, and how that can infiltrate the workplace and amongst colleagues. I think it's very easy for the lines to be blurred. So coming on to my last case, so this has a slightly different result. And an employment tribunal has held that supporting the Rangers Football Club did not amount to a protected belief under the Equality Act. And this was because Mr McClung had supported the Rangers for 42 years and was a member of the club and received annual birthday cards for them. He never missed a match and spent most of his discretionary income on attending games, as well as watching them on television. But the Employment Tribunal defined Mr McClung's belief as being a supporter of Rangers, but concluded that it was not capable of being a protected philosophical belief under the Equality Act. While it was not in dispute that the belief was genuinely held, it concluded that the remaining criteria outlined in the case of Granger plc versus Nickleton were not satisfied. So that case of Granger is what the Employment Tribunal and the EAT would have used for the previous two cases for McCarrick and my Four-Starter. And those criteria are that the belief must not be an opinion or a viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion and importance, and it must be worthy of respect in a democratic society, not be incompatible with human dignity and not conflict with the fundamental rights of others. So the Tribunal had regard to the explanatory notes in the Equality Act 2010, which provide that adherence to a football team would not be a belief capable of protection, so it actually said that within there, which was helpful. The definition of support being actively interested and concerned of success of a particular sports team contrasted with the definition of belief. And while Mr McClung's support for the Rangers was akin to support for a political party, case law suggests that support for a political party is also not a protected belief. And actually I think we'd be in trouble if it was, especially given the latest events. So support for a football club is actually akin to a lifestyle choice, is what they held. So it didn't represent a belief as to be weighty to substantially affect human life. So some people I'm sure would argue otherwise after losing a football game. And it had no larger consequences for humanity as a whole. So there is a wide range of Rangers fans with varying reasons behind their support, and that's shown in very different ways. There was nothing to suggest that fans had to behave or did behave in a similar way. And support for the Union and loyalty to the Queen were not prerequisites of being a Rangers supporter, as Mr McClung had submitted in his claim. So the only common factor was that fans wanted their team to do well, and therefore lacked the requirement characteristics of cogency, cohesion and importance. In terms of where does that leave us, well, it's quite tricky really. These decisions illustrate that employment tribunals as well as employers have the right to balance individuals' competing and conflicting views within the workplace, and tribunals are increasingly separating out an individual's protected belief from the way they manifest that belief. So where the reason I read out those points with regards to how my Four-Starter has reacted and Dr McCarrick is because I think that you could draw differences in their attitude as to how they express themselves within the workplace, and I think that is something that the Employment Tribunal focused on when coming to their decisions. As I said earlier, it is permitted for employers to introduce and enforce some boundaries on how beliefs are expressed within the workplace, but it should be noted that protection does not apply to holding a belief. The Tribunal's decision in the Four-Starter case makes it clear that how you express it is also capable of being protected. Again, the facts will be very case specific, but just remember that this is quite a low bar for protection under the Equality Act, so always have that in the back of your mind when dealing with these. That's my advice.
I think that just means it's a nightmare for employers in this particular area, which is why we put it in, because it's very topical. Who would have thought football support isn't a belief that's protected under the Equality Act? But never mind. Back to me. Sorry, The last part of the day, I'm just going to go through the sickness, absence, and also keeping that topical with sort of long COVID. Again, it might be in a couple of years we don't have to have a sickness absence part, but again, we're not quite there. We're not quite there yet. I think the starting point really is that all legal restrictions, including requirements to self-isolate that we've become very familiar with, were removed earlier this year. So despite that, it's still likely that illnesses, not specifically COVID, but that could include, of course, flu, and I think that is tipped, should we say, to come back in quite a big way, because that has fallen off the last few years. We'll still have quite a large part to play in sickness absence levels for the foreseeable future, bearing in mind, of course, we are going into the next winter period. So really the onus is therefore very much on employers now going forwards, and they will need to effectively consider how best to plan and manage these types of issues in the workplace. Thought, as Helen has moved me on to the slide, which just gives a few figures, so just to put this into sort of context. Now those are figures that are taken from the latest ONS data. Now bear in mind that takes a while to filter through, so some of it is the most recent one that's published earlier this year, but it may reflect a slight delay period before. What it does give a good indication on, and why I put it up really, is that approximately 2 million people are estimated to be experiencing sort of long COVID type of symptoms, and the most commonly reported are, as you might expect, things like fatigue at over sort of 50%, shortness of breath, which again with a lung condition you might not think is unusual, but also having coughs and muscle aches as well. It is one of those conditions, however, that isn't that it is highly individualised. So it fluctuates, it can come, it can go, as I understand it, and also it will affect people very differently. So again, that might, and I'll come on to that, the reason for that, why it might make things a little bit harder or more easy for a disability perspective. Now, nearly half of all organisations have had employees experiencing long COVID symptoms, which have lasted 12 weeks or more. And over a quarter of organisations reported long COVID as one of the top causes of long-term absence. So it still seems to me that although COVID and related issues are still causing issues in the workplace and have not quite gone away. There's been a few changes to SSP. There were changes brought in on account of COVID and during the pandemic. So it's just worth highlighting that SSP is no longer payable from day one of absence due to COVID-19. I know we mentioned it earlier on. Therefore, the three-day waiting time before SSP commences from day 4 becomes payable now and applies to all, in respect of all absences. Okay, so employees with a COVID infection are no longer considered as being incapacitated for the purposes of eligibility to SSP. So what does that mean? Well, that means an employee must now actually be sick or incapable of work to be eligible for SSP. Those who are asymptomatic or only have very mild symptoms will no longer be eligible for SSP where they were to test positive. So therefore, anyone who tests positive for COVID but remains fit for work will not be entitled to SSP. Now that potentially creates issues for employers, especially where the job role is such that COVID positive employees or workers are not able to effectively work from home. So what does that mean? Well, you could have employees coming into the workplace, into the office, into the wider workplace as well, or going out and seeing clients that could infect others. They could become unwell. That's going to lead to increases in your own other absences, and also increasing the risk to those more vulnerable staff, so perhaps those with a disability or those who are perhaps more at risk of issues that are related to those sorts of illnesses. Just also worth noting that the SSP rebate scheme, which allowed employees with less than 250 staff to reclaim SSP paid for the first 14 days, has also stopped, no longer applies. Some changes to fit notes as well. Some of you might have seen this already. There was new regulations that prescribe a new form of fit note which does not need to be signed in ink. You might have seen that, and no longer contains a signature box. And they've also increased the categories of people who can sign fit notes. So that was extended to include things like registered nurses, occupational therapists, pharmacists and physiotherapists. Now I think all of that stems back to when there was such a problem on getting fit notes in the last couple of years. So perhaps that has sort of eased a bit. But bear those in mind, especially if you get a fit note that turns up that ordinarily you think, well, it's not signed by a GP or a doctor, and that was from July this year. So now, what can we do about that? So we've got to deal with options really for employers in this sort of circumstance, and this is sort of graphically put on the slide, which I'll talk you through. So it does assume there that an employee is open about their status, and bear in mind many may not be testing anymore, may not have tested to confirm a positive COVID status, which could make things harder to tell. I think that really the starting point there is that where unfit for work due to a COVID or similar, staff should not undertake work until they're well enough. So that's quite a nice easy one. Where it's the case, where that is the case, of course, then they'll be entitled to SSP after the 3 days now, or contractual sick pay if they are entitled to that under their contract or handbook. So what can be done where the employee is well enough to work? Now this is a lot more tricky. So working from home is perhaps the easy answer. But it's not going to be suitable for all. There are going to be plenty of roles, job roles and businesses and industries where that's not going to be possible. Now, interestingly, the government has produced quite a lot of guidance over going back to around March, April, May that deals with this, and it's completely silent on how employers should deal with the scenario in practical terms for those who are unable to work from home. So what do we suggest? Well, where working from home isn't possible, there's a couple of things that we can do. We could look at the possibility of considering a different role on a temporary basis, so therefore sort of amending duties to a role that would allow for part home working. That would need to be done with agreement with the individual. Employers, I've seen some employers do this, still offer contractual sick pay where there's a positive COVID test for a set period of days, so for example 5 days. And really what that's doing is it's a disincentive to coming into the workplace and potentially spreading things around. Allowing employees to continue to work but with mitigations in place. So that's taking us back to mask wearing, PPE, safe, socially distanced areas, increased ventilation and those sorts of things, which I think most businesses have tended to sort of have in place but have sort of perhaps worked through now. The probably most least attractive option, I suppose it is an option, is to just say, well, come in without any mitigations. I think that really does risk the spread of illness around in the way that we've said, and that could increase your general absence rate, but also increase risks to vulnerable employees as well. And bear in mind, there might be a health and safety angle to that as well, so it could really be contrary to an employer's sort of general duties to take reasonable steps to protect the health and safety of the staff and others. Now, as a final point on this, whilst at present it's not been tested fully in the courts and tribunals, where you've got a COVID positive employee who presents, which I suppose would be the same flu, who presents themselves as capable of work, and they turned up to work and they look at the state and coughing and spluttering everywhere, and the employer decides to send them home. Now, that's an option. It's probably not a bad option, but it's likely that they would still need to be paid for that time. So bear that in mind where you're electing to send them home. So again, a few options really for employers here. It won't probably come as a surprise for a lawyer to stand up here and say, review your sickness and absence procedures, which is still good advice. The reason we say that is because things might have changed. So for example, the SSP requirements have changed over the last few years. So it's possible that there could be some adaptation, whether or not to require employees to inform their employer about a COVID positive test, you could put that in your policy. Whether COVID absence will be treated or disregarded for the purposes of your absence management triggers, and whether there are any amendments to sick pay entitlements, as I've said, perhaps bearing in mind SSP changes. Any reviewed policy should really bear in mind both an employer's duty, as I've already said, under health and safety legislation, and its duty to make reasonable adjustments for those disabled staff members, now which importantly could include steps to mitigate the risk of spreading COVID-19 and then catching it. although that might be, of course, quite difficult to prove. And as always, an updated policy should be communicated to staff, and it should be implemented fairly and consistently. So we've got a few sort of tips there on what employers should be doing or help to manage absence. Now the next issue, carrying on I should say really, is long COVID. What we've got on the slide there is a tweet earlier this year by the UK's equality watchdog, the Equality and Human Rights Commission, and they stated, without case law or scientific consensus, did not recommend long COVID be treated as a disability. Now, many were critical of that and expressed concern at the stance being taken, and so the next day they published something else. Following day, they effectively gave a statement to clarify that, which effectively said that at this time, although long COVID is not a condition which automatically constitutes a disability under the Equality Act, in reality there's only a few of those, HIV, multiple sclerosis, cancer, etc. Long COVID might amount to a disability, and it would be determined by the courts and tribunals. Also went on to say that employers should follow existing guidance when considering reasonable adjustments and flexible working in order to support affected workers. So, where does that take us? Well, I've got up on the slide there what the definition of a disability is for these purposes, and that's set out in section 6 of the Equality Act. So if long COVID is to be a disability, then those suffering with it will need to meet the definition under the Equality Act. Now initially it might have actually been quite less likely that long COVID would be regarded as a disability, but now, given that we've got more evidence, there's been further time that have progressed, there is much more evidence of people still experiencing symptoms for much more than 12 months. So that, to my mind, increases the chances really that those suffering with post-COVID related illnesses could be considered disabled for these purposes. However, it's not just about how long it goes on for or is likely to last for. It also needs to have a substantial adverse effect on day-to-day activities. I think, as I said a moment ago, it seems to me a very individualised condition in the sense that it affects people very differently and also sort of may come and go to a certain extent. So I think the best advice there is that the only way you're going to be able to tell that is to obtain a medical report. That would be the best advice really, to try and tease out what is the condition and how it's affecting the staff. Now we do have a little bit of case law on this, not a great deal, but it is quite a helpful case to give an example of a flavour of how the tribunals are dealing with these things. The case referred to on the slide, the Matthews case, considered the issue of COVID illness in relation to an employee who had resigned and brought claims of disability discrimination. Now, since she contracted COVID-19 in or around March 2020, she'd found it difficult to do things like lift heavy shopping bags because of numbness in her hands. She wasn't able to do her own housework, and she found it difficult to cook. She was also unable to stand for any length of time because of low oxygen levels. So that had, I think it's fair to say that had a significant effect on day-to-day activities. She also experienced a deterioration in her mental health due to these symptoms, the ongoing symptoms that she was suffering. Now, she was described by her treating doctors as post-COVID, but no medical prognosis was given about the length or the likely length of these symptoms. Now, the relevant time was in June 2020, which is when the tribunal were required to, that period of time was when they were required to look at the relevant disability or not. Now, the claimant was being treated with asthma inhalers, she was being treated with other medicines, including strong painkillers and antibiotics. So taking all of that into account in the preliminary hearing, the tribunal concluded that she was suffering from a physical impairment, which was substantial in nature. Now, even though there was no medical prognosis available about the duration of the physical symptoms, the tribunal reached a view that whether those symptoms could last for 12 months or more, and they came down on the side that they could, and the result being therefore that she was considered to be disabled under the Equality Act at the material time. Now, I think it's a good helpful case just to really set the scene and flavour, and just to make and reinforce the point that long COVID certainly could amount to a disability, but of course it will depend upon satisfying the tests that we've gone through. How it's dealt with in the tribunals is a good indication really of where we are. As I say, there is more of a body of medical evidence now that I think will help more than likely support that than make it less likely of a fine. So again, what can we do about that? Well, ACAS is quite good. ACAS has got some good guidance on long COVID, which is advice for both employers and employees. The guidance broadly reflects, it doesn't depart hugely from what employers should be considering anyway when dealing with any long-term sickness absence. So while off sick, employers should normally be looking to agree how and when to make contact during any absence, make sure their work is covered, shared out appropriately within the team, and look at ways to support a return to work when that's possible. Employer really should also be looking at support they may need, and what will an employer really want there? They will want to get medical evidence, they'll want to get an occupational health assessment or medical report. Consider whether there are changes that need to be made to the workplace and different working hours, if not on a temporary basis or permanent basis, and a phased return to work, especially with the COVID type of related issues. Now, as with any potential disability, discussing and agreeing reasonable adjustments to the individual is going to be key. Now, I've got another diagram as a final slide, and this really is more of a reminder really of the general key points when dealing with any long-term sickness absence. So that's whether or not it's COVID related. Now, always bear in mind that any long-term sickness absence can be due to a disability, and that duty of reasonable adjustments may therefore apply. That duty to make reasonable adjustments is on the employer. Okay? So if there's any doubt, best practice is to assume that the individual is disabled under the Equality Act and to consider reasonable, looking at reasonable adjustments. Now, this condition in particular, as I've said, is likely to change over time, and different reasonable adjustments might therefore be necessary as it progresses. So I think what I'm saying there is it's not just a one-time thing, it might be something that changes over time. Now, as with many long-term sickness absence cases, which are, by the way, generally speaking, very difficult, not easy to deal with in practice, medical evidence should be attained rather than the employer sort of receive wisdom. Tribunals really hate received wisdom. They want to see that you've looked and you've got that medical evidence to try and see what the prognosis is, so that you're going in with the up-to-date evidence to make a final decision. Now, depending on the length of absence, it may well be necessary to revisit the medical position, seek further medical advice. So again, just because you've done it once doesn't mean you shouldn't do it again. And certainly before taking any decision to dismiss, you'll want to check whether anything has changed, particularly whether a prognosis is any different. Now, this is particularly the case with new and highly individual and variable conditions such as long COVID. And finally, when considering the issues around prognosis, employers should bear in mind that treatment options may well improve in the future. So meaning that some long-term absences may actually then be able to come to work, because quite often you're looking at whether or not how long can the employer wait, or how long should the employer wait if, for example, there is evidence that there is some form of new treatment that the individual is either taking or might be able to get the benefit from. That may then be a relevant factor when you're reaching that final decision on what you're going to do with the employer.